Do you remember Sameer Wankhede, the IRS and formerly NCB officer who was recently in the news after the recent OTT series made by Aryan Khan featured a character based on him? In October 2021, Wankhede was all over the news after arresting superstar Shah Rukh Khan's son Aryan in the Cordelia Cruise drug bust case. But today, he is back in the news in connection with another case, this time before the Central Administrative Tribunal or the CAT, which administers service related disputes. Hello and welcome to The Print. This is Khadija Khan from New Delhi. While pulling up the Central Board of Indirect Taxes and Customs or the CBIC for abusing the process of law, the Central Administrative Tribunal on Monday set aside the disciplinary charges framed against the Indian Revenue Service officer Sameer Wankhede while restraining the authorities from taking any further action against him. On Monday, a bench of CAT chairman Justice Ranjit More, along with Justice Rajinder Kashyap in a 79-page ruling said, such conduct of the respondents is not only demonstrative of malice in law, but also constitutes an abuse of process, being actuated by personal vendetta and designed to harass and prejudice the applicant. This is what caused the tribunal, which usually adjudicates service disputes, to set aside the disciplinary charge memorandum, which was issued to Wankhede on August 18th last year, while pointing out that it did not serve any legitimate purpose of service discipline, but was purely a retaliatory measure in complete violation of Articles 14 and 16, which relate to the fundamental right to equality and non-discrimination. Significantly, the court also noted that in a gross abuse of its power, in May 2023, the Central Bureau of Investigation or the CBI had filed a frivolous case against Wankhede without even getting proper sanction from the competent authority as is required under the law, and immediately after this case was registered, a raid was carried out at Wankhede's residence when nothing incriminating was found. The raid was conducted a little over a year after Wankhede had arrested Bollywood actor Shah Rukh Khan's son in the Cordelia Cruise drug bust along with 19 other people. The present case against the IRS officer, who is currently posted as an additional commissioner under the Ministry of Finance, Revenue Department, related to a challenge to an August 18, 2025 charge memorandum, which is essentially akin to a charge sheet and was issued by the CBIC against him. The controversy arose when the tax body had acted against Wankhede despite the tribunal's order in April last year, which said that no coercive action will be taken against Wankhede. But first, let us understand what is a charge memorandum. A charge memorandum is basically a charge sheet in a non-criminal case consisting of a formal document, usually detailing specific allegations of misconduct, negligence, or financial discrepancies against an individual. However, in the present case, the court emphasized that it is well-settled law that a charge memorandum must contain all relevant details like the list of documents and witnesses relied upon so that the officer can effectively defend himself. The two-judge CAT bench also made it clear that it was restraining itself from imposing costs on the CBIC and the Department of Revenue with the hope that they will mend their ways and establish an administrative mechanism that upholds the rule of law. In doing so, the bench noted that the conduct of the centre in converting an interdicted preliminary inquiry into a full-fledged departmental proceeding, despite subsisting interim protection, reflects gross malafide vindictiveness and a colorable exercise of power. This was done with the singular objective of tarnishing the reputation and the image of Wankhede in the eyes of his peers and the public at large with a view to victimize him, the bench noted. What was the case against Wankhede? The present case against the IRS officer, who was currently posted as an additional commissioner under the Ministry of Finance Revenue Department, related to a challenge to an August 18th charge memorandum, which is essentially akin to a charge sheet and was issued by the CBIC against him. a man who had busted drug rackets and gangs in Maharashtra and Goa, was now being targeted unfairly by the political bosses of the drug mafia, Wankhede said in his plea, while also pointing to his role in drug-related cases like that of late actor Sushant Singh Rajput and Aryan Khan. Wankhede also told the cat that the former minister Nawab Malik had grabbed an opportunity to take revenge and had started defaming him by putting false, cheap, and baseless allegations on his integrity, career, caste, and family. Not only that, these allegations trickled on to his family members like his old father, sister, and dead mother, he said. However, these allegations were found to be baseless by the Mumbai police, and he also lodged an FIR against Malik at the National Commission for Scheduled Castes. In 2024, Wankhede also filed a case in the Bombay High Court against Malik over the caste-based remarks, causing the bench to issue notice and seek details from the police about the investigation into Malik. After this, the Special Inquiry Team was set up under the then Deputy Director General, despite the DDG leading another criminal investigation against Wankhede at the same time. Saying that the DDG could not have been a judge in his own cause, Wankhede challenged the SET's report from June 2022, arguing that there was a violation of natural justice in his case. In response, the government filed a plea against him in the Delhi High Court, where the court in February 2024 refused to quash the findings of the SIT. By this time, Wankhede had become a prisoner of the process. The CBI had also registered a case against Wankhede for a frivolous offence, relying on the same SET report which had been challenged, the bench noted, while adding that even in the CBI case, no sanction was given by a competent authority as the procedure requires. Aggrieved, Wankhede approached the Delhi High Court in 2023 but withdrew his petition after the CBI lawyer told the court that he should have approached the Bombay High Court and not the Delhi High Court, since the former was the appropriate forum in his case. After this, Wankhede made his way to the Bombay High Court again, which in May 2023 granted him interim protection from coercive action after examining the credibility of the material before it. The grant of such interim relief is indicative of the fact that the Bombay High Court found substance in the grievances raised by Wankhede, the bench noted. Dissecting the ruling. In the present case, however, the bench had to deal with a challenge to a charge memorandum from August 18th and said that the Supreme Court in the 2012 case of Prabhash Chandra Mirdha had held that a charge sheet cannot be challenged in a writ petition since it doesn't give rise to any cause of action unless the same has been issued by an authority which is not competent to initiate departmental proceedings in the first place, pointing to the well-settled legal principle that interference at the stage of issuing a charge sheet can only be permissible in exceptional circumstances. The bench said that only when there is a clear lack of jurisdiction or patent illegality can a charge sheet be interfered with. It also reiterated that judicial review at the stage of charge sheet is justified whenever the foundational legal defects go into the root of the matter. Despite the tribunal halting any further action against Wankhede in April last year, it noted that the CBIC and the Department of Revenue had acted in gross disregard of the same and resorted to issuing the charge memorandum against him on grounds of misconduct by a public servant. Such an act on part of the respondents is not only a blatant act of judicial indiscipline, but also a deliberate attempt to render ineffective the orders of the tribunal, the bench noted. The action of the respondents unmistakably reveals that they are hell-bent on punishing the applicant by any means whatsoever, even if it requires them to trample upon the majesty of law and openly defy the authority of this tribunal, the cat bench said. And that brings us to an end of today's segment. For more legal updates, keep watching The Print.